Zoning Board of Appeals to order. And before we launch into the agenda, I have a brief overview to present here. The Zoning Board of Appeals is a group of 7 of your neighbors or peers appointed by City Council to pass judgment on requests for variances and other matters that are brought before them. A variance is a relaxation of the literal provisions of the zoning ordinance. Petitioners must indicate a hardship or practical difficulty running with the land that would warrant the granting of the variance. The board will hear the items in the order that they appear on the agenda. When an item is called, the chairman will verify that the petitioner is present. Then the city administration will summarize the facts of the case. The petitioner will then be given an opportunity to address the board to explain the justification for the action requested. After the petitioner makes their presentation and answers any questions the board may have, the chairman will open the public hearing. Any person wishing to speak on the request should raise their hand, and when recognized by the chairman, come up to the podium and sign in on the sheet provided. The speaker should identify themselves with their name and address, indicate their relationship to the property in question, for example, a next-door neighbor, and state whether they are in favor of or against the variance request and give reasons for their opinion. Comments must be directed through the chairman. Comments should be kept as brief as possible and closely pertain to the matter under consideration. Only one person will be recognized by the chairman at any one time. At the conclusion of public comments, the chairman will close the public hearing. Once the public hearing is closed, no other public comment will be taken unless in response to a specific question by a member of the board. The board will then make a motion to approve, deny, or postpone the request. In order for the request to pass, a minimum of 4 votes for approval are needed. If the request is not granted, the applicant has the right to appeal the board's decision to the Oakland County Circuit Court. And also introduce the members of the board who are here tonight. Starting on your right, my far left, is Michael Bartnick. Next is Tom Stratt. He is not only a member of the zoning board, but also a liaison from the Planning Commission. Myself, Dave Lambert, the chair. Next to me is Alan Neal. He is the vice chairman for the board. Next to Alan is Bill Fisher. And then last but not least is Ken Courtney. Representing the city administration, we have Paul Evans, who's the zoning and compliance specialist. And last but certainly not least, Susan Lancaster, the assistant city attorney. And with that, Mr. Evans, would you read the roll call, please?
Thank you, Mr. Chairman. Mr. Bartnick.
Here.
Mr. Clark. Mr. Courtney.
Here.
Mr. Fisher.
Here.
Mr. Neal.
Here.
Mr. Lambert.
Here.
Mr. Stratt.
Here.
Thank you, Mr. Evans. Next on the agenda is the approval of the minutes. Is there a motion to approve the minutes from the last meeting or any questions or corrections to those minutes?
Move approval.
Okay. Mr. Courtney has moved approval, seconded by Mr. Neal. Any discussion or questions on the minutes? Seeing none, we're ready for the roll call.
Mr. Courtney?
Yes.
Mr. Fisher?
Yes.
Mr. Neal?
Yes.
Mr. Lambert?
Yes.
Mr. Stratt?
Here. Yes.
Mr. Bartnick?
Yes.
The minutes are approved. One thing that seems to be missing from the agenda, we had it last time, and I believe it's in our rules of order, is approval of the agenda. Did that kind of get missed this time along on this agenda?
Oh, I think you're right. Yep.
Okay. Do we have any additions or changes to the agenda?
Mr. Chairman, if I could, we have
Sure.
one slight change. Tonight's variance request for the postponed item 3, the applicant has indicated he'd like to withdraw, but he'd also like to make some comments to the board. So in that light, I propose that instead of handling his withdrawal at this time, we proceed with him coming to the podium and addressing the board.
Right.
Other than that, no changes.
All right. Any changes from the members of the board? Seeing none, we will then go on to the postponed items of variance request from Minal Gada and Ashish Manik at 4820 Livernois. And is this appropriate to turn it over to the petitioner now, Mr. Evans?
Yes, I'll do a brief introduction as he approaches the podium.
Okay. All right. Go ahead, Mr. Evans.
For the audience,
Mr. Chairman,
Yes, Mr. Stratt.
I may have a conflict of interest here, financial. I'd like to excuse myself.
You're so
Okay.
excused. Thank you for bringing that to our attention. Okay, Mr. Evans.
thank you, Mr. Chairman. This property, just for the refresher of anyone watching, is located on Livernois Road, just south of Long Lake Road. Public hearing was first held by this board in March of this year to consider a variance to allow the petitioner to split his lot into 3 lots, 2 of which would be which would contain less lot width than what the ordinance calls for. There have been subsequent postponements to this matter, and it's before the board tonight. And I just want to give that brief summary.
Any questions from the board for Mr. Evans? Mr. Bartnick.
My recollection is that if the petitioner has decided to withdraw the request, that he is allowed to do that, and we don't have to actually ultimately make a ruling for dismissal or approval. Is that correct?
Yes, I agree. If he decides to withdraw, he just want to make some comments to the board.
That's fine.
Okay.
Any other questions from the members of the board? Mr. Neal.
Just a question in this regard is, and it's more from my own knowledge, but in this case, would this be really a public comment situation, or would it really still be an agenda item? I know it doesn't change anything in how we do this. I'm just curious from my own knowledge.
I think, based upon my belief, this would be a regular agenda item because it is still a postponed item in front of the board, and then we would then consider the petitioner's request withdrawal. Any other questions? Yes, Mr. Bartnick.
Just a clarification, I don't think it's that we have to consider his request to withdraw. If he makes a request to withdraw, I think it's withdrawn. Is that correct?
I don't, ask the staff.
That is correct.
Okay, all right.
Yes.
Thank you for the question. Appreciate it. Okay. Petitioner would address the board now.
First of all, I'd like to say that my wife, she wanted to join me today, but she had to take my daughter to a music class. I live on this property, 4820 Livernois, with my family. And I would first of all like to thank the board and the staff that they've been helping me and, having to postpone the request from March 15, 2011. Yes, I am intending to withdraw, but I felt that it would be fair on my behalf just to let board know why I'm withdrawing it. After our hearing in April, we had an obligation or a fact that we came to know that the historic district has to be de-historized, and so we applied for it, and we applied for the month of May. And what happened is we were told that from May it will take 90 days for them to react and take a decision. However, that's why we postponed it to August and September. All that point of time from May onwards till last month, the end of last month, I was told, I was waiting, as the board was waiting to hear from the more things, and I was shocked to find out that the department had not worked on it at all, and they did not do anything about it. So it was not the department, but the historic district department at that point of time, with whatever reasons what they had. And knowing the fact, what I know that that particular department has been passed on to zoning division, and Mr. Paul and Mr. Brent are a person in charge of I had a meeting with them, and even today we don't know, but they are, at least I know that they are working towards it, and we don't know what is the end date for that or decision date for that. So as per our last meeting, I felt it was good for me to withdraw. Apart from it, that I might be able to come up with a different plan and resubmit it again. But I just wanted to thank you guys, and I just wanted to let you know it was not my side that I was just postponing on or not showing up. It was just I was waiting on the information that I did not have, and I still don't have it. Okay. Thank you very much. And I am very, very much optimistic about City of Troy, because I still have some good plans for it, and I hope things go good from from this point on. And thank you very much. Thank you.
Any questions from the board? Yes, Mr. Bartnick.
Mr. Chairman, I just wanted to thank you for showing up to let us know that.
Appreciate
sending
it.
us that courtesy.
Thank you.
Appreciate that.
Thank you very much. Thank you, sir.
Any other questions? Mr. Courtney, you have a puzzled look on your face like you have a question.
At one time, the ordinance actually had no teeth at all, because it said that if the owner petitioned to have his property withdrawn from in a historic district, it was automatically coming off. Did they change that part of the ordinance?
I'm not aware of any portion of the ordinance that says it now. The process we have to go through now is actually delist it, which involves a number of steps.
Okay, then
Yeah.
they have changed that
Yeah.
some. Because I know I laughed heartily at the ordinance the way it was before because it meant nothing. The only thing it was there for at that time was if I had a piece of property and I wanted to get some special tax exemptions, which you could get with historical districts, that was the only thing it was there for. Now it evidently has some teeth and really is a historic ordinance.
If I can, again, I don't know if this is off record, but Mr. Courtney, you are, when I bought this property and I was doing a lot of changes with it, I was offered this from the department and I did not take any of the credits for this particular property. Not a single one.
Yes, Mr. Neal?
I do have one question, sir.
Sure.
Just to make sure I understand. When you get the information you need, you intend to reapply?
What is that, sir? Sorry.
It's my understanding that once you get the information you need, you intend to reapply. You might
Yes.
modify ideas, but
I would modify and reapply, yes. I intend to do that as yet.
okay. All right.
Did I answer your question?
Yes, it does. Thank you very much, sir. Mr. Chairman, I have a question for staff.
Sure, right here.
It comes to a question of fairness. I know that we had, when this had been delayed a couple of times, we had at one point reached a kind of a drop point where we were going to pull the item, and then if they wanted to go forward, the applicant would have to reapply, pay the fee, and et cetera. And I don't know for what reasons this might have happened. I'm sure just because of administrative follow-up. He hasn't been served by the city as well as we would like, let's say. If he's going to come back, do we have any leeway on not having to incur, or the applicant, incur the extra $150 fee?
I think that's definitely something the department could consider.
Okay.
Appreciate it.
It's just my understanding is that if the historical commission, for whatever reason, wasn't able to take up the issue, it's a chicken and the egg issue. He's got to wait for them.
And I think that raises a good point in that it took a lot longer, I think, than anyone would hope.
Right.
And now that the planning department has taken over the administration of the historic district ordinance, we have an idea of how much time it might take.
Okay.
But nonetheless, I think it would be fundamentally fair to definitely consider at least assisting him perhaps some way, shape, or form.
Well, I only asked because I just don't want to violate a policy somewhere, so that's why I directed to you and whatever it's just my comment.
Definitely something we can consider, yes.
Yes, Mr. Courtney?
Yes, if we just tabled the item, he wouldn't have to reapply then. He could just bring in the additional information. There'd be no question as to whether he pays again.
Table it till when?
He wants to withdraw.
6 months at a time.
Mr. Chair.
Mrs. Lancaster?
Yeah, he wants to withdraw, and I think you have to respect his request. In terms of returning a fee, there is Chapter 60 of our ordinance where City Council establishes fees. I'm not sure what fees are on that charter or on that chapter, if in fact they're established by resolution of City Council. I think we'd have to look to see if we would have to petition City Council to waive the fee for him because they set the fees. But it's something we can do. But, at this point, he's asked to withdraw it, and I think you should respect his wishes. You're actually, if you table it, that's not what he wants, and he is the petitioner, and it's his right to do that. So I would suggest you just let him withdraw. And we'll talk about trying to get him the fee back later. It's up to the board, but you'd be voting to table something that is not his request. And I understand why you want to do that. You want to give him a break, but at the same time, we'll try and work with the fee thing instead.
Any more questions from the members of the board? Seeing none, thank you for coming. As
Thank you
Mr.
very
Martin
much,
said,
and happy
thank you for
holidays to
coming
all
out.
of you.
Thank you. You
Thank
too.
you.
And I assume as far as business is concerned, it'd just be noted in the minutes that the petitioner withdrew and the board
Would like-
recognize the withdrawal. And
That would be fine, and then we can also make a note for future reference that would consider a possible fee waiver if that's possible under our ordinances, so.
Great, thank you. And Mr. Bart, thank you. If you see Mr. Bartnick out there, have him come back in, so.
And Mr. Stratt.
I'm sorry, Mr. Bartnick's already here. I'm allowed to make a mistake every now and then. Okay, with that, we are done with the postponed items. We have a hearing, no hearing of cases. Communications, as far as I know, we have no communications. And public comment, we would open it to public comment, but there's nobody here from the public, so we'll pass on that. Miscellaneous business. We have the city attorney comments on the written meeting minutes that was distributed to each of us. And I want to kind of add a couple of questions onto that, not necessarily about the minutes, but a request that I sent to, I think, all the members of the board that had email, and that was some clarification on, as the city attorney and Mr. Evans are giving us some information or answering questions on the written meeting minutes, to address some information to the board on, number one, policy or procedures when somebody wishes to abstain on a vote, and secondly, crafting resolutions on variance requests. I was wondering if you'd like to go into that spiel right now, or before you go into the spiel, if there were any questions from any of the board members about the written comments that were given to us on the minutes. Mr. Bartnick.
Mr. Chairman, since I probably instigated a lot of the discussion about the minutes, I just wanted to compliment the legal department and especially Susan Lancaster, the assistant city attorney, for the work that was done on it, and it's resolved all of the questions that I had about the process, and I wanted to thank her for doing that.
Thank you.
You're very welcome, and just for further information, I'm not sure I noted it in the memo, but I did talk to the other attorneys about all of your concerns, and they were okay with how the minutes are set up now, so thank you.
Okay. With that, I guess, would you like to go into your presentation, and then we'll have the board address any questions that you may have for us on those two topics.
Paul and I never know, because we do this song and dance where he's knowledgeable and I'm knowledgeable, so who to talk first, but because I'm the only woman here, I get to talk first. So, and those of you that are married know how that works. So, basically, in terms of a conflict of interest, I'll go into that, and I'll let Paul start on the minute part when we get to that. But basically, city charter says that if you're a member of council, you must vote. But those are elected officials, so you're elected for your vote. If you have, the charter says, a financial interest, you may abstain from voting if you state on the record you have a financial interest. Thereafter, it's up to city council to decide if you're allowed to abstain. And so those rules don't really apply to you, but they do show that the courts do, or the thinking is that if you're an elected public official, your job is to vote. And the idea behind that is that if you don't vote and you don't put it on the record, the public doesn't know if you're not voting because it's a difficult issue or a political issue and you don't want to vote. So it's rather mandatory for council people to vote because they're elected and you need to tell them why you're not voting. The general rules, as they apply to your board, are that anytime any member that's serving on a board has a financial interest, it's your duty to reveal that. And the accepted practice is usually just what happened tonight. Mr. Stratt said he had a financial interest. You don't get to decide whether he has a financial interest. You've got to take whoever says that at it's his word or her word. And he did it properly. Usually you leave the meeting so that you don't influence in any way or can't be accused of influencing the meeting. So, and then when the agenda item is done, you return for the next agenda item. Generally, one reason why we changed the ordinance to add additional members who would fill in, would be on those situations where we knew there might be a conflict to get your full 7 votes. As far as I know, City Council has not appointed alternates to this board, and that's always helpful in situations where either someone is absent or you got a conflict, because then you can you want to make sure that the petitioner gets due process, and sometimes if you're short members, your votes might be skewed a little bit. So in terms of financial interest, that's an easy question. You have to reveal that. They also call that a pecuniary interest in some case law, and you must abstain. But then you get into this gray area about what if there's something else that maybe I don't have a financial interest. And by the way, financial interest means a direct interest. You're going to somehow get some money either through your employment or through your employer, or your employer is going to get money that's going to trickle down to you that you actually have. It's not just a general financial interest. If we're all taxpayers, so you can't use that. If it's something that applies to everybody on the board, that's not a financial interest. It's got to be something more direct. But now getting back to the direct interest, financial interest, those gray areas where, and the best example I can think of is, suppose your next door neighbor that you've been living next to for 25 years comes before you, or, and maybe even more significantly, your brother-in-law comes before the board, and so far I don't think that's happened. Then this board has to decide how you want to handle those times where it's not a financial interest, it might be a personal interest, and there might be what is technically, and I'm sure Mr. Bartnick has heard this term, an appearance of impropriety, where the public really doesn't know if that's going to influence your vote or not. And then this board can make some decisions. You can decide that you're going to accept that as an excuse and just have someone say, I have a personal interest in this, and not make them explain it. Or some boards actually vote. They'll require you to say you have a personal interest and maybe explain it a little bit, and then vote whether or not you believe it's going to influence that person's decision. Or that's not what, that wouldn't be the vote, but the vote would be, yes, we want you to excuse yourself. So you can make up your own rules regarding this, depending on how you want to handle that. Again, you do have a public duty to vote, and the courts would look in these situations as whether or not that personal interest would jeopardize that person's right to a fair vote. So you balance those two, and if you think you can do it, if you've been living next to your neighbor for 25 years, but you know you can be fair and impartial, then you shouldn't be excusing yourself. If he's somebody that you go to ball games with every weekend and you're over at his house every weekend, then maybe you want to consider whether or not. But it's a very personal decision. So those are the issues that you have to decide how you want to handle that. It's not the financial. Those are automatic. You have to tell when there's a direct financial interest. So basically, I think it's up to the board to mull it over and think, how many times has it come up where we actually had a personal issue where somebody wanted to say that, and it would be up to the person involved. I mean, for all we know, you could have a personal interest and not say anything, and that's your personal choice because you're here to vote. But if you want to abstain, then it's up to the board to accept that as an excuse and just allow you to leave, or to make the decision whether you want to make it a rule that you will vote on it, and if that person is required to stay. So you got to balance how far do you want to force that person. If that person is really feels very uncomfortable voting, do you actually want to vote and make him stay, or do you want to accept his reason for not leaving? And again, some of you have been on the board for quite a while. You can kind of go back and think how many times that's happened. It doesn't happen very often that it's a personal. It's usually a financial interest. So basically, that's a short summary, and I'll ask Paul if he wants to add anything.
I guess the only thing I would add is that, in my experience, some board members, not on this zoning board, have indicated that they would perhaps not want to be in a position to vote on whether or not one of their co-members would need to step down. If an individual board member believes and announces that they have a conflict of interest and announces that reason, what certain board members have told me on other boards is that that's essentially enough for them. And one board member posed a question that said, if you have to go in front of your own colleagues and ask, isn't that enough right there to say maybe to avoid the appearance of impropriety, that board member should just recuse themselves from hearing that case? But that's all I have to say.
Mr. Courtney?
We've had people, though, mention a possible conflict, but that they don't think it would affect them in the past, and we've had a vote that allowed them to stay voting. In other words, did not excuse them. So they don't always want to be off just because they bring the subject up. I know if my next door neighbor were here, I don't think it would affect me, but I think I would have to let you know that I'm hearing my next door neighbor's case. I wouldn't necessarily want to be off, though, just because I brought it up.
Well, and you, if I may, and you raise a good point in that in order to be transparent, the board member is mentioning that. We don't know who knows what out in the public, and quite honestly, if you fail to mention it, even though the facts would never change, would it lead to a public distrust or perhaps a perception of non-transparency? So the fact that a board member mentions something to advise that they don't believe it's a conflict of interest, that it will not negatively affect, you've been very upfront with everyone. And of course, I would say this, if anyone on the board feels otherwise, we always have the option to discuss that as a board before we proceed further.
And to add a comment to that, the general rule is that you are appointed to vote. That's why you're here. And, you know, you're all taxpayers. You all are going to see a neighbor sooner or later. Those things, if you feel comfortable, you should vote. That's what you're here for. There might be those situations where one of you just can't do it. There's something about that you feel that you just can't do it. And they're going to be pretty rare. And so maybe you just want to, I don't know that it's ever happened. Have any of you had anybody ever say that other than, and say, I just can't vote on this? Or like you, they just say it?
Of course, I guess you could bring, when you mention the subject, I wouldn't ask to be excused. I would just say that okay.
That you have a very
I now feel
personal-
like,
Yeah,
as
personal
Mr. Evans indicated, that
Right.
it might be embarrassing for people to
Right.
ask us to vote on it when they really want to be excused. And in the way that they bring up the subject, you could tell whether they want to be excused or they don't. Yes.
And there might be some very embarrassing reasons why you don't want to vote. I mean, I can't think of what they would be, but, well, yes, I can, but, you know, we don't want to go into too much detail, but there might be some reason that you just don't want to tell the board, but you feel strongly, and then so it's up to the board to say, okay, we're going to take each other at face value, and either you're going to say, I have a personal interest, but I think I can be fair and vote, or you're going to say, I have a personal interest and I really want to abstain from this one, and it's up to you to either accept that or vote on it. And again, as Paul is saying, which is worse for the record, just to say, not explain it and have that person just not participate in the process. And again, it should be something pretty rare. So I guess if there's any other feedback.
Mr. Stratt, you had a question.
Yeah, I had a situation just not too long ago where a realtor came before us, and he actually represents me in my office building. So I felt that I had to disclose that, but I was not going to be biased by it. I was going to actually vote what I felt was right, but I did disclose it. So let the board know just exactly what you said, that you can't hide that situation. I mean, it could come up later on. And so I felt that was something I wanted to expose. I guess that was the right move. I don't know. But the board voted on it. This was a planning. And they felt that I was okay to vote on it.
Right. Well, and I think that's perfectly okay. I mean, the reason why we have a Board of Zoning Appeals is because the state, the government thinks of it as a good thing that somebody who doesn't like a decision of an administrator gets to hear from their fellow citizens, which is you, about how you feel. If you feel, and it gives them a shot to go in front of ordinary citizens like yourself and say, this is my problem, these are my hardships, will you give me the variance from the law? So there's legitimate reason for doing these boards, so that we can have citizens have due process and have a chance to talk to their fellow citizens. So it's important that you vote. It's a very important board, and it's just a matter of you all feeling comfortable that someday somebody may say, I have a personal interest here and I would like to abstain, and you're just kind of accept that, or you want some more of an explanation, or to continue to do what you're doing, which is perfectly acceptable. Say, this is my neighbor, but I'm able to be fair and reasonable and do it that way.
Yeah.
Mr. Fisher.
I've just in the light of transparency, do we have a responsibility, should a neighbor present to us, to let the board know that this is my neighbor?
There's
So
no-
that so something in the future comes back and maybe a decision was skewed a little bit, or that they didn't like it, and they come back and say, well, that was a neighbor there, so in light of
There's no
transparency, we don't have to worry about
requirement,
that.
there's no, we don't have any kind of ethics rules that require you to say it. It's a matter of you feeling comfortable in your skin that you can be fair, and let's face it, there are certain things that we might have issues with. Some of you might, I remember serving with Mr. Strata on the Planning Commission, and he was very into drainage, and I remember every time we had something he had drainage questions. He was concerned about drainage, and that was always a big issue with him. And some of you have ideas that, whether it's setbacks or something, so there's always going to be some concern that each of us have, that you can't call them prejudices, but there are concerns that you're going to be more scrutinizing about those issues. And the same with having a neighbor come up. As long as you feel that you can scrutinize the ordinance based upon their hardships, there's no requirement that you say, this is my neighbor. It's whatever you feel comfortable with.
I guess a comment and then a question. The comment is actually my very first ZBA meeting, my brother-in-law is the architect for Whitechapel Cemetery, so I had to request the board's permission to recuse myself for fear that I wouldn't be welcome at family gatherings after that point.
It's one of those real personal
Yes.
reasons you want to keep going there for Christmas.
Yes. The second is a question, and the only time I recall somebody other than having a financial conflict abstaining is if they are a brand new member of the board and there's the motion to approve the minutes from the meeting where they're not even a member of the board. Is that an appropriate abstention, or should we maybe put something in the minutes saying member XYZ abstained because they were not a member of the board at that meeting?
That's whatever you feel comfortable with. Technically, you may vote if you were not there, if you vote because you're approving them as written. But if you don't want to, if you feel comfortable and you don't want to, you may abstain. That's kind of a personal thing. But technically, there's no requirement that if you weren't at the meeting, you can't vote during that roll call to approve, because you're approving them as written, and whether you were here or not. But you may also abstain if you feel uncomfortable. We don't want to make you do anything you feel uncomfortable doing.
Any more? Mr. Bartnick.
Thank you, Mr. Chairman. The new ordinance calls for not absentee members, but alternate members to be appointed. And it seems to me that one of the reasons why they did that was to address this question and the absentee question. Mm-hmm. And both of those would, the abstention issue would be a little bit easier, I think, to make on behalf of the board if you knew that there was another alternate member sitting in the audience that would be able to step in and
we're hoping you get some alternates soon.
Decide the case, yeah.
It's, some of you go out of your way to make sure that you're here when you rather have another commitment. If you knew there was an alternate and you had a commitment somewhere else, a business commitment that you had to do, that you wouldn't feel so bad about leaving the board short. But hopefully that's going to come to fruition sometime.
Any more questions from the board on the abstention issue? Seeing none, I guess we can go into the second part.
I'll let Paul start that part.
Yeah, I'll start this part. The second part is in regards to crafting motions for variances. And I'm going to focus basically on the most common types of variances we hear, which is area or dimensional variances. In other words, a non-use variance. Now, we all know at the beginning of our agenda, the first page is the variance review standards, the 5 standards in the ordinance. And essentially, what the board's charged with is hearing the record. And the record consists of the application and all the maps and materials that it consists of, any city exhibits, the testimony or what the applicant says at the podium, and also the public comment. And essentially, the record is the record, and your decision should be based on what's in the record and how those things in the record fit into your variance review standards. If the board believes that the things that were presented to the board qualify, they're going to grant the variance. And if they don't, they shouldn't grant the variance. Now, the question comes up is, how should a motion be crafted to, say, approve a variance or deny a variance? I'll talk about approving a variance first. Essentially, we don't have to, in a motion, you don't have to list, reiterate, have a complete laundry list, or even a brief summary of the testimony if not necessary. It's perfectly acceptable to say, based on the testimony and evidence presented here tonight, I'd like to grant this variance or a modification of that, whatever it might be. Now, as you hear testimony and as information is presented, you may pick up on certain items that clearly meet one of the standards. Or maybe they meet a few of the standards, or they're just good reasons as a whole to demonstrate a practical difficulty has been established. Feel free to jot some notes or make some mental notes. When you make your motion, you can always include those factors that may consist of the reasons why you think it's a variance without reiterating all the testimony. But at the end of the day, especially if the city's taken to court, which we rarely are, and we are successful when people do challenge the Board of Appeals decision, the judge is going to say that, is going to look at the record and make sure that the decision the board made was based on material and competent information provided at the meeting. So it's perfectly acceptable to say a simple variance, a simple motion that says, based on what we heard tonight and what we saw tonight, I motion to grant the variance. And if you want to say some additional items to perhaps summarize for the public, for yourself, that either tie in specifically to items A through E or just generally tie into practical difficulty, that can be done.
By way of adding to that, Paul and I have frequently said since I've been back on the board, and I'm sure the other attorneys that have sat on this board have said to him that we are very confident with this board. You all know what you're doing. You all make good comments. We have no fear of anything you say of not being able to defend ourselves in a lawsuit if it comes to that, and as Paul pointed out, rarely does it happen. You should all feel good about how you do your records. The reason why Paul and I are here to assist, and you have to remember that a judge doesn't look just, if we're sued, a judge doesn't look just at the motion. You have to remember that Paul prepares those huge documents you look at. All of that is part of the record. Everything the petitioner submits is part of the record. And your comments, which would be transcribed, are all part of the record. There is so much that I don't know if any of you have ever had an experience of sitting on possibly a smaller city's board of appeals or a township board of appeals. The way that this board runs is super class. You have so much information. You know how to make your decisions. You're all very good at what you do. So we have every confidence that nothing could happen when you make a motion. Even if you just did a simple motion, I make a motion to grant, and you didn't state anything on the record, we have the record to support it, and we don't need to. The court just doesn't look at that motion. The court looks at everything. And we have to show that there was some kind of arbitrary decision by the board based on that record. So there's a lot of documentation, every motion to support what you do. But motions, the easiest one is just to say, for the reasons stated on the record tonight, I make a motion to grant. You don't have to even go through the reasons. I know when I first started doing this board again and the new zoning ordinance had passed and I saw those standards, I thought, wow, this is going to be difficult. But we've got it down now that the petitioner can present, and as long as we're able to justify why a decision was made, in fact, it's not even our burden, it's the burden of the person suing us to show, then we're in pretty good shape. And we just want you to know that all of you are sensational to work with, and you all know what you're doing, and none of you should ever be fearful of making a motion or worried about doing it right. I have been doing this job for 30 years for a number of different cities, and I have never seen a lawsuit where somebody said you didn't make a motion right, or you didn't follow Robert's rules, or you didn't follow your own procedures. So we hope that, with, saying it again, we enjoy working with you so much because you all know you're all very competent people. So you should feel free to go ahead, go forward, make your motions.
And as we discussed earlier, too, if you feel that our motion needs further clarification, you would jump in to help.
And usually
us
that's something, usually Paul catches those. Maybe we need a footage, or maybe we need to clarify what kind of footage or what kind of setback, or did you mean that tree? He's very good at catching those things. I try and watch for just the due process things, and rarely, I mean, you guys, I can't really think of any time that I've ever had to correct you, maybe on a little Robert's rules or something, but even that, nothing that you do is, so you should feel very proud of how this board works. You do a great job.
Yes.
Did you want to discuss the denial motion as well, Mr. Evans, or not, or do you think you covered it all there?
Well, I probably covered it all. Let me just speak out loud, think out loud if I could. Sometimes it helps with motions to deny to give a summary of some of the reasons why you believe a practical difficulty doesn't exist. You've got the applicant here, you may have supporters in the audience, people watching on TV, and I think for the benefit of those people, if you can explain why you believe a practical difficulty doesn't exist, whether it be that there's reasonable alternatives, it's too much of a request, doesn't fit in with the neighborhood, whatever it might be, I think that would lend itself to some understanding from the public as to why the person was denied. So maybe you'll, because we don't have, or you can go through items A through E here and say, well, I don't think there's exceptional characteristics. We believe it's a personal nature. It was self-created. You can always do that as well. But I think it'd be important if within the motion, either the motion maker or the seconder with some amendment touches upon a couple of those just for the benefit of the audience and the applicant, of course, who's before you.
And just to add one note to what Paul said, actually a denial motion is probably easier to defend in the sense that a denial means you're just supporting our ordinance. It's the grant that you're deviating from. So a denial of a motion is supported by the fact that you're just saying the ordinance, we're going to let the ordinance control. And then you can actually say the same thing that Paul said with the grant. You can say, for the reasons stated in the criteria for denial, we don't think, or in the ordinance, that we don't think you've presented any record, or there's been any record presented tonight that shows that there's a need for a variance, something that simple. You don't have to make it complicated. Just so, again, and the record will support it.
Mr. Courtney, you had a question?
Okay, this is the reason you had us place by special resolution that the minutes include the recorded copy, that's part of the record of the minutes.
Oh, yeah. Yeah, that's going to be a record, isn't
That's,
it?
I mean, that's why you had us specifically designate that rather than just leave it loose like it had been previously,
Well,
so that there was no doubt.
contributing. I mean, if
Yeah.
the one thing, I've only
Ties
been
it
involved with
together.
one case in Troy where someone has taken the Board of Appeals to Circuit Court because they didn't agree with the decision. And the first thing they did was ask for a copy of the video. That was the very first thing they did. And a judge is going to ask for that anyways if it's available.
Okay, but by actually making it definitely part of it, then there's...
Right, that ties it
If
together
somebody
with the
didn't
audio.
want to, if they wanted to go by just a piece of paper, you've got the other end.
Exactly.
The whole thing is there, okay. Which makes it easier for us anyway.
And a transcript doesn't lend itself to interpretation like minutes would do. I mean, it's better to have a transcript because then,
Yeah,
you know, you're hearing what was actually said and it's not an interpretation of what was said. So it all works out well to do it that way.
Any questions, Mr. Strapp?
Yeah, is it improper for one to actually express what their position is going to be on the vote and why before the vote actually takes place?
No, not at all. That's what you're here for. You're explaining, you know, and that I don't think I'm going to vote for this because of this and this and this and this. It also gives the petitioner an opportunity, if you wish to hear him, to maybe refute what you're saying and say, well, you didn't consider this kind of thing. It adds to the due process of it. You're actually explaining to the petitioner, and if the petitioner or another board member wants to point out something to you that they disagree with, then it leaves it open. So that's not going to hurt the record.
You know, and if I could add to that, I've seen boards of appeals work where a motion maker will make a motion and maybe list a few reasons, and the seconder will second it. Maybe that person will have identified yet another reason to support the motion, and then maybe a board member or two would say, well, in addition to that, I'm going to vote this way on this because of, and you might end up, for the edification of the public, basically 3 or 4 or 5 good reasons listed out by different board members that makes it very clear, at least in the board's mind, as to why a vote goes the way it goes. Or, Tom, like you said, not all votes are 7-0, and it's okay to do exactly what you said. I don't necessarily agree with this because of A, B, or C, and therefore I'm going to vote against it. And that's okay to say.
I often wondered if you're trying to influence the balance of the board, if someone does that. I don't think it's a matter of influence. I think it really, frankly, is. That's why I asked, is it improper? But if you're stating a case and stating the facts, there's no real influencing there.
No, I would have to guess with this board, if somebody were to make an erroneous statement at that time in the meeting, I'm going to guess someone's going to say, wait a minute, it's 20 feet, not 10 feet.
Mr. Courtney?
Yeah, I don't see anything wrong with trying to sway the other members. In fact, I've had a motion that I've made that somebody else brought up something that I ended up voting against the motion myself.
Yeah.
So.
Well, that's being honest.
Good point, Ken.
Any more questions for the city staff here on these issues? If not, thank you for your presentation. I appreciate it, and I'm sure we all do. Any more business to come in front of the board tonight? If not, we are adjourned.